I think the SEC is going to win. And I tell you, it's going to be a bad day for crypto if they win.
Okay,
right.
We're going to put that dinner on that?
Steak.
Steak, you got it. Okay.
They trying to drown me. I know about XRP, nothing to tell me. I ain't touching those.
Hey, everybody. It's Eddie from Tokyo. This is your cryptocurrency update from Japan. And I was just having a little fun with Charles Gasparino. I told him that I am game for the same, meaning that with the SEC turnover of the XRP sales in the secondary market, I will also put a bet, but he needs to know he's got to fly to Tokyo to pay up. I'm with Jeremy Hogan on this. Although it is possible to appeal the decision on XRP, the SEC might have a problem getting at the secondary market sales part because of how Judge Torres couched or worded her ruling. Jeremy hasn't totally solidified his thinking, but I think he is correct. As you probably know, I had the former SEC attorney on my channel yesterday. She believes it will be appealed. John will be live at 3 p.m. Eastern Standard Time with the New York crypto lawyer to walk through the ruling by Judge Torres and what it says, what it doesn't say, and the likelihood of it surviving the appellate scrutiny. He's going to stick to the facts, no disinformation and no bias. Gensler has weighed in on the ruling. Have a listen.
How does the federal court ruling last week in the Ripple case impact your stance toward digital asset regulation? Does it inject urgency into the need for federal legislation to clarify regulatory oversight of this industry?
Look, our mission remains exactly what I spoke about earlier, about investor protection, promoting capital formation, and the markets in the middle. This is a recent decision, just a handful of days ago. We were pleased from that decision, recognizing the importance of protecting investors on the institutional investors in that, and that the court movement with regard to fair notice, and while disappointed on what they said about retail investors, we're still looking at it and assessing that opinion.
And a new order did come out today for both Ripple and the SEC. This comes from Judge Sarah Netburn. She's the magistrate judge. And they are to agree on 3 mutually convenient dates to schedule a settlement conference, and if they believe it could be productive for them at this time. She recommends that scheduling 6 to 8 weeks beforehand due to the court's busy schedule. They will also discuss pretrial motions in addition to settlement. It ain't over till it's over. Ripple does say, however, that U.S. banks will want to use XRP even after a partial victory in the SEC fight. One bank, however, that has not announced using XRP is the Bank of Japan, despite this headline. This is the Crypto Alert website that has over and over again come out with fake news. Now, I'm not saying that in the future they could decide to use it, but as of now, there has been no announcement. And another fake news story that is been spreading since 2018 is that SBI's CEO, Mr. Yoshitaka Kitao, said that every bank in Japan will use Ripple's XRP by 2025. He has never said that. This article cites an interview with CoinPost. That article is still available to read, and I put a link to it from my Twitter account. I can guarantee you there is nothing about every bank in Japan using the digital asset XRP.
Switching gears, I want to ask you about crypto.
There you go, Jennifer.
You didn't think I was going to let you off the hook, Chair Gensler, did you? All right, so last week we got a major ruling from the Southern District of New York on Ripple. How does this ruling change your approach, if at all, your abilities when it comes to regulating crypto and specifically crypto exchanges?
Look, our approach has been the same. It's about protecting investors, facilitating those who want to raise money, and the markets in the middle. And that's true whether it's in other parts of the securities markets or the parts of the crypto markets that are securities. And in terms of the decision, we're still taking a look at it. We're pleased with how the courts addressed itself to that a token for institutional investors is a security, how they address themselves to fair notice, disappointed in other aspect about retail investors, but we're still taking a look at that and considering it.
Coinbase is already relisting Ripple. A lot of these crypto exchanges feel like this was a real win for them, that the tokens that they list on their exchanges are not securities based on this ruling. So what do you say to them? Are you concerned about potential precedent that this could set, especially for other charges that the SEC has brought against other crypto exchanges?
Look, again, Jennifer, you're asking good questions, but there's ongoing litigation with regard to a number of these crypto platforms, and these crypto platforms are commingling a number of services that you've seen on these crypto platforms where they could well be trading against their customers, bundling up a bunch of services that we would not allow in any other parts of our capital markets. So the investing public comes first. That's how our securities laws were first written. Companies raising money in the markets as well, and really protecting them and protecting the integrity of the markets. But I'm not able to go into any ongoing enforcement matters.
So it sounds like it's still sort of an open question. I wonder, there's been some confusion that's been generated from this. Does it make you reconsider writing customized rules for crypto?
Again, it's too early. This was like 3 business days ago. But I would note, the agency has rules on the books right now. It's about full, fair, and truthful disclosure if you're raising money from the public and the public's anticipating profit based on the efforts of others. That's why Roosevelt called it the Truth in Securities Act. There's rules on the books about what it means to be a securities exchange, what it means to be a broker, an investment advisor. There are rules on the books. We've also put forward or even adopted rules with regard to broker-dealers in this space called special purpose broker-dealers. We've put forward proposals with regard to the safeguarding of those assets, or even exchanges in what's called the decentralized finance space. So we've done some of that, but again, we'll continue to consider.
Republicans on the House Financial Services Committee have put forth a discussion draft on a framework to regulate crypto. And within that proposal, they're looking at laying out guidelines that would direct which firms would need to register with the SEC. They would have you write customized rules. And I think the biggest point is that they would have a decentralization test to decipher whether a token is a security, a commodity, or both. I'm curious what you think about these principles, especially the decentralization test.
Jennifer, we are asked by members of Congress, both the House and the Senate, on a regular basis to look at their various pieces of legislation, and we generally give them our feedback directly rather than through the interviews on the. So
decentralization, good idea, bad idea in general?
Yeah, I'm going to again. save our comments on any draft legislation for our members that are asking us directly. But this field, the crypto field, Satoshi Nakamoto writes an 8-page paper, and it was at the core of that paper was this concept of moving value on the internet without a central intermediary, a central bank or a commercial bank, but moving value on the internet. Whomever Satoshi was. This field is actually quite centralized. Around each of the tokens, there tends to be a group of entrepreneurs, and you can find a website and you can look, and there's maybe a Twitter account and somebody that might even have a name of a CEO or CTO, Chief Technology Officer. Around the platforms, they're quite centralized as well. So this is a field that is not immune to the economics of finance. Since in antiquity, finance tends towards some centralization, and that's what we've seen happen in the crypto field as well.
The first half of this year was marked by more than a dozen enforcement actions by the SEC when it comes to the crypto space. Should we expect more of the same in the second half of the year? What can we expect from the SEC when it comes to regulating crypto in the second half of the year?
I think over the last 6 years, we at the SEC have brought, settled, or litigated somewhere close to 150 actions in the crypto field. So I don't know what the next 6 months will hold, and I'm not at liberty to speak about any one enforcement action. But we're really focused on protecting the integrity of the markets, the investing public, capital formation, as I said earlier, and trying to bring greater compliance within this field.